have this massive litigation-driven process driving policy to spend money and set deadlines and dictate government activities. Instead of working hard to save species, we're working hard to spend money on litigation about species.
When one litigant can drive all of the policy, it marginalizes all of the other land users.
If we didn't settle with them, that they would fight it every step of the way, said we'll take it to the Supreme Court if necessary. You'll have to hire a water lawyer, it'll become very expensive. And in essence, told us that they were going to break us.
Through the years, they just take a little here, take a little there.
The Equal Access to Justice Act was really implemented for small business. And the idea there is by giving them the ability to get reimbursed if they won in litigation with the federal government, it would level the playing field. The problem is now it's been utilized not by small business, but by big activist groups to force policy and to make money in the process.
The Equal Access to Justice Act was extended to nonprofits, and it's become a fundraiser for them. The environmentalists bring lawsuits, and often they bring 5, 10, 15 claims under the National Environmental Policy Act, the Endangered Species Act, the Administrative Procedures Act, and all they need to do is prevail on one claim in order to ring the EJA bell, we'll call it. I don't think that it's fair to the taxpayers or the government that if you prevail on 90% of the claims that the environmentalists have brought against you, that you have to pay their fees because they prevailed on one claim.
Most of the things that they're making us do on the Oregon side is based on that, on the litigation. Here's the reasons why we have to do these, is because litigation.
What they pretend to advocate is preservation of wilderness. And I don't think there's anyone in their right mind who's opposed to preserving those areas that are worthy of preservation. But you need to do it in a rational, realistic way.
To the extent that environmental plaintiffs have the ability to decide which venue they want to file in, there are certain places they seem to be attracted to. There are some judges that tend to be more sympathetic to certain kinds of claims than others.
You know, there's the old joke that says, you know, a good attorney knows the law and a great attorney knows the judge.
We have litigation, costs going out of agency budgets that were designed to be spent for boots on the ground conservation. Yet those monies are not going to conservation. They're going to pay lawyers who are suing the federal government.
Some of these environmental groups have $20, $30, $70 million budgets.
I had a conversation with plaintiffs' counsel, and basically I told them, I said, you know, I represent a lot of landowners who have the opportunity to do conservation practices on their land, and if we can help them understand things that they can do without putting them out of business, I said, there's a number of them who will step up and be examples, and he thanked me for it, but said we get more bang for our buck out of litigation.
There's serious problems in the federal bureaucracy. It's very complicated, it's very large, it's dysfunctional.
Public land states like Utah and like Nevada are bearing disproportionately the burden associated with large-scale federal land ownership. Those who will say, well, you know, this does benefit the whole country to have a lot of federal land. If that's the case, then the whole country ought to bear the cost of it.
We have to have fact-based discussions about what's really going on out here, and we have to put a halt to this emotional propaganda that's being spewed, particularly by these so-called environmental groups.
We're allowing one or two organizations to really drive the entire train.
Hi, I'm Representative Mike Noel from Kane County. I would like to ask you for your help today to help us fight a battle that we've been waging for quite a few years. It's a battle against those entrenched environmental organizations that have used the Equal Access to Justice Law, EJA, to go into the courts and to file litigation. Many of it is frivolous litigation, which then costs individuals and the public and the government more money. It's very important that people hear the real story behind the Equal Access to Justice Law. It's been abused. It was really meant for veterans and older people to access the legal system, and now it's been taken over by a group of wealthy environmental organizations and their lawyers to sue with our funds, our needed tax funds, sue our own federal government, sue states, sue individuals, and try to stop access to these public lands. We need your help, and we need you to contribute. Go to our website, policybylitigation.org, and give your funds. Thanks. This is Mike Noel from Kane County.